In this video, we are going to take a look at a residential purchase contract as well as some commonly used addenda in writing offers. Now, we're going to be looking at it on the utahrealestate.com website. If you're ever in need of getting to the forms and can't get into Brokerment or you're away from your computer or whatever, you can always go to utahrealestate.com, forms, URE, legacy forms library, and then you can pull up the forms. Okay, the purchase contract. We know that the header includes the offer reference date. This is the date that has to be included not only on the offer, but any subsequent addenda at this time and all the way through the terms of the contract. Buyer names have to be included, seller names have to be included. Obviously, your buyer names are how they're going to appear on title, so make sure that you have your buyer name spelled correctly. Seller names. Not all listings will have the seller name available immediately on the listing. It's good practice to contact the seller agent to find out how they want the names to appear on there. They can also be taken off of the property tax data. Keep in mind, property tax data tends to do last name first, first name last. So you want to make sure that you have it the way that the sellers are comfortable with. Also, make sure that if it is in a trust or an LLC, that the full name of the trust or the company name is on there. And that can sometimes be rather space consuming. The longest I saw was 2.5 printed lines long because of the nature of the investment property and subsequently the offers that were used. All that could be put in there was C addendum 1, and I had the list of them copied and pasted the whole name onto addendum 1 because it was so long it was never going to fit every time. Owner of record is really incomplete and not as professional as doing your homework and finding out the owner names. Okay, make sure that when you put in here the earnest money amount in the form of either you use a check or wire transfer, our brokerage is able to accept both. Remember that cash can't be used for the earnest money amount. By putting check or wire transfer, it allows your clients the opportunity to either use a personal check or a cashier's check, or up to certain amounts, we can take wire transfer. If you're looking at using a wire transfer, check with your transaction coordination team first, or with Michael Butt, our office manager, to make sure that we're not exceeding the limits on a wire transfer. Okay, property address, make sure you put the street address, city of, county of, and then zip code, and copy and paste the tax ID number off the listing. Okay, all of those have to be in there for this to be complete. Be aware that city of sometimes can be, you may see, particularly in some areas like Kearns or Sandy, it may say Kearns, may say Salt Lake, may say White City in parts of Sandy. Make sure that the name is in there according to what's on the property tax, and then it's most accurate. Okay, included items. Obviously, this is the checklist: washer, dryer, refrigerator, or microwave. And then copy and paste anything else in there and make sure you get the other marked. If the listing shows on inclusions and you copy and paste, it shows washer, dryer, refrigerator, and then other items, you may choose to delete that and simply mark washer, dryer, refrigerator up above. It's going to be your choice. Microwave ovens, keep in mind that many older homes may not have built-in microwave ovens. They're simply one that's sitting on the countertop. Although having recently sold a property that was the nature, we left the microwave oven behind. But if I was buying the house, I'd have just kind of got a new microwave oven for $100 at Walmart. They're not that expensive. Whether there's are or are not any other separate items for bill of sale. This is if you're looking at they're leaving behind a snowblower, a snowplow. We had a home with a very large driveway. The sellers were leaving a four-wheel drive, a little four-wheeler with a snowplow blade on it. Luxury homes, oftentimes with furnishings. Anything like that is not typically considered an attachment, oftentimes will go here on a separate bill of sale. At closing, that bill of sale will be signed again. Just as verification as to what the price breakdown. Lender may require that from for the buyer to explain what amount of the purchase price goes toward these other items because they may not include those in the appraisal value, and buyer may have to pay for those separately. I had a home that my buyer was purchasing that had a car lift in the garage out back, and because it could be dismantled and carried away, we had to negotiate back and forth on whether or not that lift was going to be left in the garage so that he could also work on his cars. So sometimes you'll have those type of things come up. Excluded items, copy again, best practice is copy and paste exactly off the listing what is there. So there's no disagreement over it. Okay, water shares, water service, and most of the time you're going to be dealing with water service that is part of the culinary water that's already attached. You may occasionally have water shares, which are irrigation water. Those water shares may be excluded because they are separate, considered separate property. They're shares of a company that provides the water. If it's water rights, and those water rights are tied to having a well or whatever provides the culinary water to the home, contract assumes that those stay with the property. You can't sell away those water rights and then leave the new homeowner without water. And the home would be of no value at that point in time because it cannot be used as a home. Okay. Payment and purchase price. This is where the offer price goes in. And then the most common errors made with this portion are just doing the math, making sure that the earnest money deposit matches up to what was listed at the beginning, paragraph 1, and that whatever the intended down payment amount is by the seller, you take that amount and subtract the earnest money to come up with the balance due of cash at settlement, so that the two combined add up to the total amount of the down payment. To come up with the new loan amount, you then take the down payment, subtract it from the offer price, and put it here. So, for example, if we have a $500,000 home, and I don't like it when you got to put the commas in there, otherwise, to me, it just doesn't look right. And they've got a $5,000 earnest money deposit. They're not putting additional earnest money. Put zeros in there. Seller financing, we're going to skip down to, and if it's a seller financing, there's an entirely different addendum that has the terms of seller financing on it that have to be included with it, and you have to put in there the amount that's being seller financed. Okay. Now, let's say they're using an FHA loan and they've got to do a 3.5% down payment. Okay, well, let's take a look at 500,000 times 0.035. That's $17,500 for the down payment. Well, earnest money is already 5,000 of that, so I'm going to subtract 5,000 from the 17,500, and I'm going to put that the balance due is the 12,500. Now, great. I still need to know what the loan amount is. So I'm going to do the 500,000, subtract the 17,500 that they're putting for a down payment, and that tells me their loan amount is going to be $482,500. So that when you add all of these, all the upper column up, it should add up to the purchase price right here. Okay. Sale of buyer's property. This is if they have to sell any type of property to qualify for the purchase of this particular property. If it's their primary residence, if it's a piece of raw land, if it's any type of real property that has to be sold, that has to be disclosed on this, because it is going to affect the terms of ultimately of the purchase. From the seller's perspective, they have to be aware of that because it could cause a delay. You also then have to include that the addendum that states that, whether or not it's listed or whether or not it's active. Okay, so make sure it is or is not. First time home buyers obviously is not. Move up sellers is. Some move up sellers choose to sell the property first and then not have to mark this and feel like they're being rejected because they've got to sell the property. Settlement and closing. This is what your buyers need to understand are two separate events. Settlement and closing are not the same thing. Settlement is, according to the contract, when all of the documents have been um, have already been signed by both sides. All the documents from title have been communicated to both sides, and all of the money has been transferred. So the buyer has transferred whatever balance that they were required toward payment. All of that has occurred. That's settlement. Closing is the funding and recording process when all of those documents are then sent to the lender for the lender to verify that settlement has occurred, that the buyer still qualifies for the loan, and everything gets pushed through and then recorded at all of the payments are dispersed by title to the initial loan is paid off, any secondary loans are paid off, all the compensation is paid off, the buyer or the seller receives whatever credits they have remaining. All of those have been paid off, and the county has recorded a new deed of trust and new ownership. That's closing. Now, all of that under the contract, you have 4 days to complete that. That means if you've got a buyer who signs everything on a Friday afternoon, that may not all be completed by Friday closing time at 5 o'clock. And consequently, they're not going to be moving in over the weekend. You've got to understand that they don't own the home until closing has occurred. All of those steps have occurred, and a new deed of trust is recorded, and they are the legal owners of the property. There is one case in Utah that went to litigation because buyer signed everything on Friday, realized that it wasn't going to close on time, but they'd settled. The home was vacant. Seller signed an agreement allowing the buyer to put all their personal property into the garage of the home and not have any access to the rest of the home. Just put their stuff in the garage, and then when the closing process completed on Monday, then they would be given keys and access to the rest of the home. They could do what they wanted to do because the home would be theirs. Buyer agent, in a hurry, just gave the keys to his buyers and just said, whatever you do, don't do anything with the house. You don't own it yet. Here's the key. Just put your stuff in the garage. Just put your stuff in the garage. And that's it. Buyers put their stuff in the garage and they figured since everything was supposed to be done Monday, they might as well get a head start on the remodeling they were going to do on the kitchens and bathrooms, and began the process of tearing apart a couple of bathrooms and the kitchen. Went to Home Depot and Lowe's, a couple of places, ran up massive credit card bills to buy all the stuff they were going to use for the remodel, expecting that Monday morning everything would go fine and they just go from there. Well, of course, Monday morning rolls around and the loan processor picks up the file to complete the closing process and dispersing the funds. And lo and behold, they no longer qualified because their debt to income ratio was too high. They'd run up all these credit card bills over the weekend. It showed up Monday morning. Their credit score dropped. They no longer qualified. He couldn't fund it. It doesn't record. Home doesn't belong to the buyers. Still belongs to the seller. Seller now has a home that's been completely trashed, has to kick the buyers out of the garage. Buyers don't know where to go. They've turned in their 30-day notice on their apartment, and a couple of horrible lawsuits followed because primarily with the buyer agent, because he just handed over the keys rather than holding the keys and supervising that his buyers didn't get into the home. Okay. Settlement upon recording, possession upon recording. That just simply means as soon as it's recorded and we have a new deed of trust from title, then the buyer has the right to start moving into the home. You can also negotiate time after recording, particularly if you've got a seller who's a move-up seller, is selling this property to move up into another one. They've got to wait for the person ahead of them to move out, and that person may have to wait for somebody else to move out. So your first-time home buyer buying this home to make sure everybody else can move up may actually be the last one in order to move because everybody ahead of them has got to have time to move out. That can be negotiated. When you're looking at hours after recording, that's typically 1 to 3 days, so 24 to 72 hours. If you're going more than 3 days, then I recommend you go a number of calendar days after recording. This cannot exceed 59 days because the lenders are going to expect that the buyer take possession within 60 days. Honestly, if it's going to go more than about 4 or 5 days, then you may want to have your buyer and consider putting an offer or with the offer, putting a lease back agreement. And there is a lease back agreement addendum that can be used to help protect them because once they buy the home, they're technically the landlord over the seller that hasn't moved out yet. And they want to make sure they've got the landlord protections for that. Prorations, this is determining on how to prorate if there are any overdue homeowners association dues, property taxes, rents, interest, all of those, the actual math will be taken care of by title. But this comes up if there's any kind of special assessment against a property. If the homeowners association had to do some type of massive repair, either for catastrophic event, storm damages a roof, or they're upgrading the pool, any kind of assessment that is assessed against the property owners, who's going to pay that off? Is it going to be expected that the seller pay it off through the proceeds from the purchase because the assessment came into place while they owned the home, while they own the property? Is it going to be the buyer because the seller says, well, yes, there's this assessment, but you're the one who's actually going to get the benefit out of it because you're the one now that will own it? Are you going to split it between the two? The buyer needs to understand that their lender's going to need to know if there's just going to be this massive, outflow of cash at settlement to pay that off, how that's going to affect their reserves. So, talk with your buyer about those. Escrow fees, rental deposits. If the property is in any type of short-term or long-term rental situation, this is how that gets taken care of. So the new owner has credit for any prepaid rents and moving forward. Keep in mind that this is one of the areas that does actually survive closing. If a home is a rental unit and has a month-to-month rental, then the 30-day time period, the renter could be required to move out. If it has a signed lease, which is a periodic lease, which has a specific date and time when it's effective through, that survives, and the new property owner has to recognize that lease. And that does include short-term rentals. If somebody rented it as an Airbnb, all those future rentals have to be recognized. And additional rentals can't be put in place without prior written permission. HOA and other entity dues or fees upon closing. There are two different types of fees typically charged at closing in an HOA. The first is commonly referred to as a reinvestment fee or a settlement fee or investment, community fees. There are different names for it, but basically what it is when the homeowners association is charging either a percentage of the purchase price or a set amount of money that go every time the property transfers ownership, that money goes into the HOA's reserve account. The most common form of this is a percentage of the purchase price, oftentimes a decimal percentage, or you'll see like 1/3%, or which is 0.33%, or you'll see 0.5%, 0.5% of purchase price. That's the most common kind. That could be charged as well as an HOA transfer fee, which is the fee the HOA management company charges to transfer the HOA membership to the new owner and cancel the existing owner's HOA membership and set them up as a new member. That's usually a dollar amount, anywhere from 50 to I've seen 250, whatever the HOA is going to charge on that to do the paperwork. Who's going to pay that? The seller, the buyer, or split it? Some HOAs don't allow the seller to pay. It's written in the CCRs, and your buyer is going to have to plan for that as a closing cost, do it settlement. Sometimes they can negotiate with the seller for that in terms of a seller credit. Okay. Compensation. This is the portion of the REPC now in paragraph 4 where buyer and seller can negotiate back and forth what amount of compensation the seller is willing to pay as a third party to the buyer agent, either as a percentage of the purchase price or a dollar amount. This has always been negotiable, but this is now puts it specifically and explicitly in the REPC. This is one of the ways it can be covered on the various compensation scenarios that we covered in a separate video. It's becoming the most common way because now it's written directly into the REPC. It is the buyer directly negotiating with the seller. It's not between buyer and seller brokerages. It's between those two parties. And you need to be aware, of course, that as the buying agent, you can't receive anything above and beyond what is already listed in the buyer agency agreement. So if you signed a 2% on that and seller says they're willing to offer 3%, the buyer broker agency agreement only allows you to collect 2%. So keep that in mind. Or you can choose a flat fee. It's what you worked out with in your buyer broker agency agreement. And some lenders are now asking to see the buyer agency agreement to verify that we're within those guidelines, particularly if the amount that's being contributed here it does not cover the full amount, and you're therefore having your buyer also pay an additional amount at settlement as a closing cost to cover whatever balance there is. Okay, confirmation of agency, agent's name, license number, brokerage license number, and whether or not they represent the seller, of course. This becomes an issue here if you're doing limited agency and you're representing both buyer and seller. You need to mark that you represent both buyer and seller. It can also be if the seller agent or listing agent is from Prime Real Estate Experts and you represent the buyer, then you'd have to mark that it's at the agents, or excuse me, the brokerage level that this limited agency situation comes about. Okay, title. This is where title, we explained we're going to order a title report. Title insurance is required by the lender to protect the lender in the event of any kind of default related to title. Cloud on title shows up later, or the title doesn't transfer properly. Seller, of course, seller has to provide title insurance to the buyer that the seller is providing clean title to the buyer. As buyer, your title cost is tied to the loan amount, whereas as buyer, the seller's title cost to you is tied to the actual purchase price. Short and long-term rental agreements and any type of bookings, also this states where this is where they continue after sale. Now, you'd think this would be fairly obvious. You'd think agents would pay attention to this, but I did have a situation in the neighborhood I lived in for 20 plus years where a young single guy purchased a home that had been a rental. The whole neighborhood knew it was a rental. He packed up all of his stuff. He'd been living in grandma's basement, puts it all in the U-Haul, drives to his new house, all excited to move in, takes the key that his agent had, wherever his agent had hid it, said, okay, go ahead and move in, unlocks the front door, and there's somebody in his house. So when he walked through, he knew there was somebody living in the house. What the seller's agent and the buyer's agent had both failed to communicate was that it was a rental property and that the person living in the home was a renter, and that the rental agreement survives closing and the renter had right to remain in the home through the terms of the contract. Now, it worked out fairly well because in this case, the renter had already been notified and was in process of packing and moving out that same weekend. But now I got a buyer with all of his stuff in a U-Haul parked in front of what should be his house and can't move in because the renter's still there. He was single. He took a trip to Yellowstone and came back. But when he told me about that later on, I'm like, you have any idea how many causes of action you have against your agent for failing to tell you that this exists and this was the situation, and as well as the seller's agent for failing to adequately communicate that this was a rental property and there was a renter in the property. Seller disclosures. This is a list we know of everything that the seller can be requested to provide to the buyer, the most common being the property condition disclosures. They're required. Lead-based paint disclosure, that's required if you're going to do an offer and it's there. All of the CC&Rs, any kinds of rental agreements that are in place, water rights, property, all of those. These are all, again, required. They can also put anything else they might want to know about. Buyer due diligence, this is whether or not you are going to choose to use due diligence as a condition for being able to cancel the contract. Typically, we're going to mark, yes, it's going to be um, inspected. And here's the list of items that the buyer can then look into. But it's the buyer's obligation to do their due diligence. We can assist them. We can provide professionals to them that can do the inspections, provide the information they're looking for, but it's up to them. Buyer's right to cancel or to resolve objections. This is where the buyer due diligence resolution of due diligence addendum comes in if there is a due diligence issue that has to be resolved. Now, if we get past that deadline, that's considered having now been resolved, and the buyer at this point waives any opportunity to cancel based on due diligence related items. This is also now where we move to the net, and earnest money shall become non-refundable. Except FHA and VA in some very limited situations based on the FHA VA addendum, that if we've gone through all of the repairs that we negotiated with the due diligence, and then the appraiser requires any kind of as a appraisal condition, but we'll get to that in a minute. Okay, but that gets the next spot, appraisal condition, whether or not the property will be appraised. Again, if the property appraises at purchase value and the buyer can qualify, then it's assumed they're going to be moving forward. If they fail to cancel before the appraisal deadline, then it's considered that they've accepted the terms of the loan, and now failure to settle would be a case of buyer default, at which point in time we'll get to what happens in the event of a default a little bit later. Now, financing is required. Buyer's right to cancel before financial and appraisal deadline. Now, this gets kind of interesting because it says buyer's obligation is conditioned upon buyer obtaining the loan reference. That condition is referred to as financing condition. If checked, if the REPC is not canceled by the buyer, provided in sections 2 or 3, the buyer agrees to work diligently and in good faith to obtain a loan. In other words, they have to go through with it. But if in buyer's sole discretion is not satisfied with the terms and condition of the loan, buyer may, after the due diligence deadline referenced, cancel the REPC by providing written notice to the seller no later than the financing and appraisal deadline, whereupon what amount of the buyer's earnest money deposit shall be released to the seller without the requirement of further written authorization. Now, this can be a pretty sticky spot. If your buyer just flat out decides they're not interested in the home anymore, and they've already gone past their due diligence deadline, and yet they've already proven they can qualify for the loan, or the appraisal's been done, the underwriting's done, lender says everything's great, seller may require that they provide proof that they don't meet the terms of the loan and that they're canceling for a legitimate financing reason. This can't be used as a backstop second hand way of getting around due diligence items. This is strictly for financing and appraisal. And if there's a disagreement over the earnest money and the buyer just walked away because the buyer wanted to walk away, the seller could argue that the buyer is in default and in forfeiture of the earnest money. Now, this does state, of course, earnest money deposits released to the seller. In the event that the buyer defaults, first option is the default that the earnest money, total amount of earnest money goes to seller. Second option is seller can have the earnest money stay in escrow and sue for specific performance. Take the buyer to court to force them to enforce the contract. That could take time and money, and seller may not have the option for it, or keep the money in escrow and go to court and seek other fair or equitable damages. Again, many sellers are just going to say, just give me the earnest money, I need to move forward. Additional earnest money, that can be used as a tool, as a way of showing how serious the buyer is by putting additional earnest money into escrow after the due diligence deadline, as we move toward financing. But that puts additional money on the line if they choose to cancel under financing terms, or if they go past the financing deadline and default. Okay, addenda. This is where you're going to list any and all addenda that are on there. FHA VA loan addendum, seller financing addendum. If these are being used, they should really be addendum number one. Then all other addenda can be named. There are some specific named addenda, such as the disclosure of interest. If you represent yourself or a family member of the first degree, parents, step-parents, siblings, or step-siblings, you're all required to do the disclosure of interest. If you're representing family that goes beyond that first degree, grandparents, aunts, uncles, cousins, nieces, nephews, it's good practice to disclose that you're related to the buyer or seller. I disclosed for my wife's nephew. I've disclosed for family beyond the first degree, just because I'd rather just simply state. Now, if you are a principal in the transaction buying this, you are absolutely required to indicate that you're using that due diligence. It should be the disclosure of interest, and that one you would just mark other and name it. Whether or not home warranty is going to be provided and who's paying for it. Most costs of home warranty is going to be negotiable. This becomes important because most home warranty plans, if purchased and paid for at settlement, become active immediately. If it's after the fact, you'll have to look at the terms of the plan, and the buyer may have to wait 30 to 90 days for it to become effective. And that's because they don't want the buyer to move in and then have the dishwasher start to break down. And so hurry and buy a home warranty and say, oh, my dishwasher is dying. They may require them to wait it out when they had the opportunity at settlement to do that. Okay. Condition, this is where we have to explain that with this. The buyer understands that it is being sold as is. There are no warranties. That's what a home warranty covers. And if there are any aspects of the home that during due diligence are they're made aware of that may require further action, and they purchase the home knowing that exists, they are knowingly purchasing it in that condition, and they become responsible for what happens after that. Seller acknowledges they're going to deliver the home in the condition it was in at the time they went under contract, less ordinary wear and tear. So ordinary wear and tear, what's that? You're moving the king size mattress down the hallway and it scuffs the wall. That's ordinary wear and tear. You're moving the box spring down the stairs and lose your grip going down the stairs, and it goes crashing through the front door and punches a big hole in the door. That's not normal wear and tear, and the seller can be required to repair that after settlement. You're backing the truck into the driveway, and it leaves a couple of big heavy tire marks. That's normal wear and tear. You're backing the U-Haul into the driveway and hit the fence. That's not normal wear and tear. Okay. Final pre-settlement walkthrough and inspection. The buyer has the right no earlier than 7 calendar days prior to settlement. So within the last week before settlement, they can walk through to determine that the property is in fact in the condition that it was in when they went under contract. This is also when they typically like to walk through and start measuring for, furniture and such. Any changes, alterations to anything that occurs during the contract period must be in writing and approved by both parties. In other words, if the seller is using it as a rental, they can't keep taking rental agreements, because that after the settlement deadline, that no longer affects them as seller, it affects the buyer. Also says the seller can't go out and take a second mortgage against the property, any kind of encumbrances. Okay, authority of signers, everybody has permission to sign it. This is the complete contract. There's nothing outside of this contract. There are no sidebar agreements. There's no, hey, my guy said he would. If it's not in writing in real estate, it doesn't exist. There's no such thing as a verbal agreement. Mediation shall or may. If there's a disagreement over the terms of the contract, are you going to obligate to go to mediation first or make it optional? Okay, we went over buyer and seller default. If the buyer defaults, so the seller has options of taking the earnest money, holding the earnest money and suing for performance, or having the earnest money held going to the court to determine what else can occur. If the seller defaults, the buyer can have the earnest money received and received up to twice that amount back from the seller, which is going to be tough if the seller doesn't have it. Buyer could have the earnest money retained and sue for performance and require that the seller sell the property, or have the earnest money retained and go to court and determine what else can be done. Then you have to cover the attorney's fees and the losing side pays. All notices must be written. Now, this is a non-assignable contract. This is where wholesalers, people who buy the home, you get it in a contract and they try to sell the contract to someone else, will have to use their own contract, or they have to get written permission from the seller to change who the buyer is. So if I come in representing the buyer, and the buyer's real intention is to get it under contract and then sell the option on the contract to somebody else for a profit, the seller has to sign and give permission to do this. This is not unilaterally assignable. It has to be both sides agreeable. Insurance. The seller is required to maintain insurance on the property up through settlement. And if there is a catastrophic event that involves any type of claim against the property by fire, vandalism, flood, earthquake, act of God, whatever else, seller has to provide, if the repairs or costs or damage exceed 10% of the purchase price, seller or buyer may elect to cancel the REPC. And the earnest money deposit or deposits are returned to the buyer. Now, they could choose to move forward. That may become part of an assigned agreement that survives settlement. What happens next? They may just choose to cancel. If they may no longer qualify for the loan. If the home burns to the ground, there's no home to get a loan on. If there's a catastrophic event and the roof gets torn off and they're looking at an FHA loan, they can't get a home without a roof on it. Conventional lender may reject it. Those kind of things occur. Time is of the essence. We do things as quickly as we can, but it's considered that any date that's a deadline, 5 p.m. Mountain Time, is the trigger time. Sign everything electronically works. Acceptance. This is important. This is an offer. It is not accepted until all addenda and counteroffers are signed by both parties and communicated to the other party. Whoever had the last counteroffer in their hands, offer or counteroffer in their hands, signs it and approves it and accepts it. It must communicate it to the other side. Now, that communication includes, you're the agent. As soon as your buyer signs this, you send it to the seller's agent. Seller's agent says, I'm going to meet with the seller. Seller says, okay. Buyer's or seller's agent calls and says, hey, I've got a verbal acceptance. They're going to sign this later. And then they get another offer that they like more, and they take that other offer. You don't have acceptance if this isn't signed and communicated, a copy sent to you. As soon as it's communicated to you by text message, email, in writing that this is signed and delivered to you, it is now a legally binding contract. That seller can't go find somebody else and say, oh, but I just got this one an hour ago and I like it more. That's not an option. They can't do that. I mean, they can, but they're going to obligate them to sell it to two people, and it gets pretty ugly. But it has to be communicated. If you don't have it signed, if all you get is the agent called and said, hey, they said yes, then they changed their mind. You didn't have it under contract before. Deadlines, dates can be either put in as a set date or as a set number of days after acceptance. If this looks like it's going to go bouncing back and forth for a couple of offers and counter offers, you may want to leave that flexibility in there, but by putting X number of days after acceptance. But that then means afterward, now you got to go through and figure out where that fits on the calendar, and hopefully that doesn't turn out to be, especially on a settlement deadline, a Saturday or a Sunday, or financing and appraisal on a Saturday or Sunday, because it's a wasted day. Okay, acceptance deadline. Whatever time you put here for acceptance must match whatever shows up on any addenda after that. Okay, and be reasonable with this when you do that. If you fill this out at 9 o'clock in the morning and your buyer gets it signed by noon and you send it off to the seller's agent, want an answer by 5, they may not even be able to get in contact with their client by 5. Best practice is to contact the agent in advance while you're finding out the name of the sellers and what the buyer agent commission is and what they're looking for concessions, all the other terms, possession, all the terms, Also find out how much time they need to respond. Okay. All right, we're going to go to the next form here. FHA VA loan addendum is one of the most commonly used because as you're working with buyers, especially for not always FHA, most predominantly first time, it can be subsequent, but VA first time or subsequent use. They have to disclose if it's an FHA or VA loan. This whole paragraph here is from the FHA lending handbook and the VA lending handbook mashed together. And the FHA lender or the VA lender may actually send you their own version of this form later to have everyone sign because because their requirement is it can only have what's in the FHA handbook or what's in the VA handbook, and this has both of them mashed together. Understand that may come up, but this is what happens if an appraisal comes in below purchase price, the accepted purchase price. FHA, if it comes in below purchase price, buyer cannot be required to purchase it at the lower price. They may negotiate with the seller for a lower price. Buyer may choose to make up the difference or between appraisal value and purchase price, because appraisal value becomes what the loan amount is going to be. VA has to go through an appraisal and then has a second review to provide a final notice of value. Very, very infrequently is the value different between the two, but it's that notice of value, that second form, that it sets the limit for how much the VA loan amount will be. And again, if there's a deficit there, then there's going to have to be some kind of negotiation, either with the purchase price, if the buyer is going to pay it outside of contract. However, all of this is part of that financing and appraisal deadline, and this states, regardless of what's in the financing or the REPC, if it's that appraisal issue is the reason that it's not going to go forward, earnest money is returned to the buyer. It does not go to the seller. Now, the appraiser could look at it and make some requirement for repairs, and if those are going to be part of the requirements for the loan to qualify, then they're going to have to look at how much are they going to require the seller to pay toward repairs. As you walk through and look at the property, you should have a good sense of if there's going to be concerns, if the property has some obvious issues, you want to look at those. If you have questions about that, then talk to me about what the most common concerns are, particularly FHA and VA. But whatever amount you put there is what the seller can be obligated to cover in repairs. In Utah, the VA, Veterans Administration, requires the wood destroying insect report, commonly called the termite report, and the seller can be charged for that at closing. Those are usually $75 to $100, depending on the inspector. Most of the inspectors we recommend will include it and bill it separately. Okay, paragraph 6 is where you can put in if you're requesting closing costs, either as a dollar amount or you can put it as a percentage of purchase price. Most often you want to contact the lender and say, what's the dollar amount that works best? And again, make sure that the date down here marked for the seller to accept it by matches the offer. Now, blank addendum can be used. The one we're actually specifically looking for this one is the closing cost addendum to the REPC. I'm going to drag that over here and load it. This is if you have a buyer who is not using FHA or VA. They're using conventional or they're using USDA, and they do want the seller to provide some kind of closing cost credit. Then this states specifically the dollar amount to be paid toward either permanent reduction or temporary reduction of mortgage rate. This is a 3-2-1 buy down or a 2-1 buy down. Mortgage financing costs, their closing fees, whatever, and prepaid to escrows. Okay. Sellers have to understand that whatever amount they obligate themselves to there is the amount. If it comes out that the closing costs, everything add up to less than that, the seller's not getting that money back. They already obligated themselves for it. Now the lender's going to use it to pay anything down. buyer needs to understand if this doesn't cover all of their closing costs, then they're going to be obligated to cover the difference. But it's the same paragraph as in the VA FHA, but this is just for use with a conventional loan or a USDA loan or product. Okay, subject to sale of buyer's property addendum. If you mark that the property is subject to sale, you're going to notice that you have to list the address of the property that's subject to. Buyer has a right to cancel before due diligence or financing appraisal deadline. So say this home doesn't sell and they run up against those deadlines and their property hasn't sold, they can cancel and still be protected. However, if they go past the financing and appraisal deadline, they're going to be following those same rules as before. Now, if it looks like their home goes under contract, but then their deadlines are not going to quite line up the way you had initially anticipated, then negotiate those. Move them as much as you can. Do what's in the best interest of your buyer, but your buyer may end up losing a deal if they can't get their home under contract. Now, they have to disclose whether or not the home is currently listed. If it is not currently listed, the buyer agrees they will have it listed within 7 days of acceptance of this offer, and then state if who the agent will be, which will obviously be you, and the brokerage. Now, if they've already got their home listed and under contract, then you want to disclose that as well. And say, look, it may not be currently listed, but it is currently under, down here, is or is not under contract. If it is under contract, it looks a little better for your buyer to be able to say, look, mine's already under contract. Now, seller then, when they see this, seller can respond however they want. They may choose to do a time clause and keep theirs on the market while you try to get this one sold, but they could put a deadline on how soon you get it back to them. Occasionally, you'll end up where you don't get the initial offer, but you want to go and back up and have it formally codified that way. You're going to use the same reference date. However, you're not going to begin the due diligence and financing process because you're not obligated to purchase the home. What this says is that the seller has a purchase contract they accepted, the primary offer, it falls out of contract. They're now obligated to contact your buyer as the first person with right of refusal. They have to contact within 4 days of the event, and your buyer then determines whether or not they want to move forward. And the deadlines become active then as of the receipt of the seller's notice that the first one fell through. And then this becomes active. If they contact and say, "Are you interested?" and it's rejected, or they decide they're going through and they've found something else and they don't want to be on this waiting list, they can rescind this as part of the offer. They can rescind the whole offer. Okay, resolution of due diligence addendum. This is added during the process, and this is what happens during due diligence as you're negotiating with the seller over how to handle the due diligence situation. First option is both sides just agree that the seller is going to provide the buyer a credit, the closing costs, and the buyer's buying it the way it is, and they'll deal with it after they take possession. Second choice is seller agrees to reduce the price. All right, there's some issues that got to be dealt with. Buyer doesn't want to pay that much for the home anymore. We'll reduce the price. Here's the new purchase price. Third option, repairs to be made by the seller prior to the settlement deadline. You list the specific repairs. Unless otherwise agreed to in writing, seller shall, through contractors, complete the work, comply with applicable law. In other words, they're going to provide proof to you that the repair work has been done in a workmanlike manner. And you want to specifically state these. Now, you can do a combination of these. You could go for accredited closing costs, but state these things still have to be repaired. or you could go for a purchase price reduction and go for closing. I mean, you could go for all three if you want. It's whatever you negotiate. The important thing is that these agreed upon repairs need to be stated very specifically. So it's easy to document whether or not they have been completed prior to settlement. Because this, you'll notice, states, but buyer remedies, if as of settlement the repairs have not been completed, the buyer may enter an escrow agreement with the seller approved by the lender, if applicable, to finish the repairs after closing. In other words, the seller has to agree that a certain amount of money is going to be withheld by title to complete those. And then as the repairs are completed, they send the contract to title for title to pay out. And then if money's left over after all the repairs are done, then that amount is of course refunded to the seller. If they run out of money, the seller still has to pay for those repairs. And again, this may be based on lender approval. The lender may not, it may be a repair the lender says it's got to be done before, particularly if it's anything that has any of the terms of the FHA and VA addendum, safe, sound, and sanitary. Primary one being a roof. If they can't verify 5 to 7 years of life left in the roof as an appraiser, and they make that a term of the loan requirements, you could use this form to verify that the seller is going to repair the roof, but you can't say, but they'll finish it a week after closing. It won't be able to close. So you need to be aware, work with your lender. If it's something else that needs to be done, like carpet's going to be installed, that doesn't get in the way of the loan, and they can't get the carpeting lined up in advance or by the settlement deadline, find out whether or not the lender is going to allow that to occur. But notice that the buyer may cancel the REPC in addition to the return of earnest money deposits if applicable, or buyer may complete if the buyer doesn't get it done, they can mark, hey, if you're not done by settlement, I'm walking away because I'm not going to be able to buy it, and I'm getting my earnest money back, or we'll go through with it, but then I'm going to still have to follow through with you on how that's going to be paid for. And then buyer due diligence condition is not waived. I always recommend this one be marked, because just because we said this is what's going to happen, it doesn't mean my due diligence deadline is over. If seller doesn't follow through with this, seller's in violation of the contract, and I want to be able to use this as a tool to help protect my buyer, but also as a club to help motivate the seller to get it done. Okay. Now I'm going to go back to the forms library. We are going to look up one more form. Disclosure of interest form. If you represent personal interest, buyer or seller is either a relative or you. This has to be included. If you're a buyer and you are a principal in buying a home for yourself, you have to state that you are the buyer and a real estate broker. If you represent the buyer and they are a relative, then you need to mark relative. If you're the seller of your own property, you need to mark that seller is real estate agent or broker. Or if you're the seller and you represent a relative. Again, the legal definition is relative of the first degree, parent, step parent, sibling, step sibling. But for your own protection, we recommend if it's aunts and uncles, grandma, grandpa, cousins, go ahead. You can provide this. I provided it for representing a nephew. Now, how often does it get used? I just completed the sale of my personal home. I had to mark that seller is a real estate broker or sales agent. The buyer happened to be buying it for her personal home and is also a real estate agent. She had to mark that the buyer is a real estate broker or sales agent. So we actually ended up with two disclosure of interest in the same transaction, for agents disclosing that they were a principal. One of the fastest ways for you to lose your license is to be a principal in a transaction and not disclose it to the other side in writing at the initiation of the transaction. That's a really fast way to get in trouble. We are going to go back and pull up one more, but it's going to be covered in more in depth with the limited agency, limited agency consent agreement. This is the agent consent agreement in the event that you as a single agent are representing buyer and seller, or you as an agent represent buyer or seller, and another agent in our brokerage represent the buyer or seller. So your buyer goes, so I'm the listing agent, continues to represent the seller, and you as the buyer agent represent the buyer's agent, or how, whichever combination. But this is the consent agreement that we're going to go through in much more detail, because at the top, you're simply filling in buyers and sellers' names, agent representing each, the company, Prime Real Estate Experts LLC, and the property involved. And then both sides need to understand what those are. There will be a separate video on this one. All right, as always, if you have questions about any of these forms, please call me, call Marty. We'll go over them with you, make sure that your clients understand them.